President of ECOWAS Court of Justice has appealed to member states to enforce judgment passed by the court, as it is concerned about the unsatisfactory rate of compliance with the judgments of the court. Asante also listed other challenges of the court. He enumerated programs of focus for the new legal year.
The judgments of this court are binding on member states, institutions of ECOWAS, individuals and corporate bodies, and the protocol gives the responsibility for the enforcement of judgment for the court to member states in accordance with their civil procedure within their various countries. It also requires each member state to appoint a competent national authority for the purpose of receipt and processing of the execution of the judgments of this court. It is worrisome that since 2005, only 5 member states have appointed their national competent authorities for the enforcement of decisions of this court, as per the supplementary protocol. These are Guinea, Nigeria, Burkina Faso, Mali, and Togo. May I therefore seize this opportunity to appeal to the other member states to take necessary steps to appoint competent national authorities for the enforcement of the judgments of this court.
The Director, Legislative Support Service, National Institute for Legislative and Democratic Studies, recommended that sanctions be imposed on any member state that failed to obey the court's judgment.
Member states have not actually risen up to their responsibility, which is a treaty obligation to respect and enforce community judgments, within their national jurisdiction. And this is actually why they must continuously understand and embrace the concept of supranationality that the ECOWAS actually community has adopted. In my view, unless member states who fail to comply voluntarily with the judgments are compelled to do so by triggering the sanctioning power of the ECOWAS authority under Article 77 of the revised treaty and under the 2012 Supplementary Act on sanctions against member states that fail to honor their obligations to ECOWAS, the confidence in the court will be eroded. I think it is in the best interest of the community citizens and the ECOWAS member states to ensure that the confidence of this court that it has built so far, with all the record actually and success stories rolled out by the Chief Registrar, is not eroded. It's not in our best interest to be eroded at all.
Ambassador Zubairu Dada, Minister of State, Foreign Affairs, assured the court of the support of the federal government to ensure an independent regional court towards economic integration.
Nigeria has always been in the forefront of promoting regional integration agenda of ECOWAS Commission. And I want to assure you that Nigeria will not relent in its efforts in making sure that the ECOWAS Court of Justice succeeds in implementing its programs and delivering fair judgments in cases that may be brought before it. It is indeed imperative to have a strong and independent regional court for its effective delivery of justice, as you have carefully chosen this year's theme, the need for a strong and independent regional court for the economic integration of West Africa. A strong and truly independent ECOWAS Court of Justice would go a long way to immensely boost the confidence and trust of the common citizens of this region in the judiciary as the last hope of the common man, as the lawyers will say, the last hope of the common man.